Paula, you're muted.
Thanks.
You're welcome.
Welcome back, everybody, to our forced labor program. I'm glad to see that people have returned after our first day session, and we're excited to continue on with our discussions from yesterday. So today I have David Murphy and Erika Vidal-Faulkenberry, and then also Amanda with Levitt back here. And we do not have Therese Randazzo from CBP. She was only available for yesterday. So we wanted to kind of change things up a little bit for today. We will not be doing PowerPoints. I thought that yesterday's presentation was a great overview of the regulatory statutory requirements of, again, are related to forced labor, and hopefully everybody has a great understanding of the process. Again, I think our speakers yesterday did a terrific job getting everybody up to date with what's going on and what Customs is looking for. So today we decided that we wanted to do something a little bit different. And we hope that it'll be beneficial to the audience. So we're going to do a couple of, we like to call them case studies. And we're basically going to select 2 products. We've already selected these products. And we're going to basically pretend that these items were subject to a WRO. And what we're going to do is have our experts here on the call kind of walk through what you should be thinking about when you're talking about providing the documentation to CBP that would be required to show that no forced labor was used in making those products. And we talked a lot about this yesterday. We talked about, there was discussion about getting, certificates of origin for tier 1 suppliers, tier 2, tier 3. But you're going to see today, I think, how challenging this can be for companies, because we really are selecting, 2 quite distinct products. And keep in mind that it doesn't matter what your product is, you're still going to have to be able to substantiate to CBP that these products were not made with forced labor and provide them with the documentation. So that's going to kind of be our first portion of the program this afternoon. Now, one thing I want to emphasize is that please ask questions, and that's really why we're here. We don't have anybody from CBP here, so you can feel free to ask your questions. We have some really great experts here that can provide you with, their thoughts on the various issues. And again, so we encourage this type of feedback. So when we start talking about, again, some of the documents that might be required, and if you've got a question that, specific to that or whatever it might be, just send it through the chat box. Once again, I'll be monitoring the chat box. When I see a question pop up, I will stop and, ask the speakers to comment on that. So that's going to be the first part. And then again, we're hoping to just follow up. I know there was a question yesterday on some of the best practices regarding documents for admissibility. So, we're going to kind of look at that as well, what we would recommend. So with that, I think we're going to basically just start with our first case study. And as I said, we have literally just come up with some products. The first product is going to be jalapeno stuffed olives. Okay, so they're coming in, they're being imported in a jar. And currently the company finds out that there is a WRO on the jalapenos. Okay, so again, now the goods are being detained. What needs to be done? And so I'm going to open this up now to our experts to kind of talk about how you're going to be able to substantiate that those products, again, were not made with forced labor, how they were made, what documents could be required. So I'm going to start with Erika. And Erika, you want to give it a shot and start, and then we can kind of have Amanda and David and add in as well.
Yeah, thank you. And I think this is going to be a very interesting format. So we can interact from the perspective that the companies might have on the realistic supply chains, and then certainly with Amanda and David on their expertise from the legal framework. So I would say with that scenario, the first thing that should come to mind for whomever receives that in the function is, what exactly does my supply chain look like and how is that mapped? And I think Therese referred to that yesterday, and if I can summarize that, is really going beyond your first tier suppliers, 2 or 3. And in that example, and I know Amanda and David are going to touch more on the legal framework around that hypothetical, it's not only, well, who are we buying or who are we importing these jalapeno stuffed olives from, but what is the country? What does the WRO says exactly? And how far does it get affected? If we are actually seeing that the WRO is for, I'll make an example, Guatemala, but we're actually importing the stuffed olives already packaged from Mexico. Well, what does that mean? Does that mean that then there is a situation because it's still an item that is by a WRO but from a different country? Is there something related with who are we buying and what are our sales terms and how far can we go? And then just lastly, before I pass it on to Amanda and David, in terms of like bringing it back of how do we will actually respond to a proactive and as well as request for information, if that would happen, is many times in the companies, the function in charge of customs compliance or receiving either that request for information or validate if there's admissibility related to a WRO, doesn't have all the required mapping of the supply chain. It might not be the customs function. It might be procurement. It might be corporate sourcing. There's something related that we have to prove with third-party audits, and Therese mentioned about those yesterday. It might be somebody related to legal. So at a start point, if that becomes a situation, there has to be a comprehensive and cross-functional look at the entire map flow of the supply chain, levels down as far as it can from tiers of suppliers, and as far as it can from cross-functional collaboration of every part of the organization that is directly or indirectly involved with a similar commodity or a product that will be made of. So I'll pass it to Amanda and David. I'm sure they can complement with some other excellent points from their side.
Amanda, if you'd like, go ahead.
Sure. I can't emphasize enough what Erika said, that this is why supply chain mapping is so important. If you are importing a jar of jalapeno stuffed olives, your relationship and the supplier that you know their name and address is likely just on that processing manufacturing facility. For business and commercial reasons, you probably haven't looked into where that jalapeno is grown. And when you're making that entry and you're declaring the MID, if customs detained your merchandise because they have the authority to do so, thinking that the jalapeno might be covered by the scope of the WRO, then at that point is when you would have to start mapping and see who it is, processed the finished product, and then also who had grown, harvested, and processed that jalapeno. So it's really essential to be prepared of having that overall mapping of your supply chain if you're importing anything that would have multi operations involved or multi components, which is almost everything that people import nowadays. And so preparing that mapping beforehand is going to then prepare you to dig deeper and ask for that documentation if and when a detention comes your way.
And this raises the issue of practicality. You're a retailer, that sells everything from jalapenos, olives stuffed with jalapenos to T-shirts.
Mm-hmm.
So trying to figure out where do I focus on? Unfortunately, sometimes it's a matter of catch-up. You can't do everything. For CTPAT, we've mapped it back to the supplier. It's basically from the supplier back that we really have no visibility. And that becomes a problem. So where do we start focusing on? So even before a WRO is issued, is usually something in the press about a certain industry or a certain practice going on in a certain country. A year and a half before the palm oil WROs were first issued, there was a lot of press about the use of forced labor in the palm oil industry. Especially if you're in the business, you probably would see those trade press about it. When you start seeing that, that's an area you should be concerned about. This is where you start talking to your social compliance people. They are probably getting something from either the public or from non-government organizations or other public interest groups talking about it. You're a major supplier of this product. What are you doing on the social compliance side? So, as far as the mapping goes, that could have been done already by your social compliance people trying to figure out exactly where it is. So that's why what Erika mentioned, the interdisciplinary activity, is really key of getting everyone involved.
And David, if I can complement a comment to your part, because it's very, very important. I think that proactive measure, as you were mentioning it also gives that opportunity for the customs function to not start building those relationships at that point, right? To get certain understanding from that social component. And for instance, things like contract governance, to hopefully take a look at those in advance, because even in that scenario that the three of us are discussing, depending on how robust or what type of relationships are with some of those suppliers in your example, if you're just a retailer, they might not have any obligation to share any details with you. So it's probably not the best time to start figuring out with whomever has those relationships in terms of governance and social responsibility when you are really being asked to provide that confirmation. So I couldn't agree with you on Amanda more.
Yeah.
Can I jump in with a question here too? Because it's relative to what you guys
Sure.
are talking about right now. We've actually got two questions and they both have to do with the ability to obtain information beyond your tier 1 supplier. So one question was, as suppliers are likely to want to protect proprietary information, is an NDA an agreement to not bypass a supplier in order? So that was one question. And then we also had a question through the chat. Importers often run into suppliers being very hesitant to provide their upstream suppliers for fear of being cut out of the supply chain. Has there been any standard requests for information, legal templates that protect both the supplier and importer, where the goal is just to obtain the data needed to map the supply chain? So maybe you guys could just, spend a minute, giving your thoughts on that, which is certainly a very relative question when we talk about this whole mapping. And just to throw in another thing, just to, which I think would be helpful, is also looking at a smaller, medium-sized company too, and how that factors in versus a company. I know, David, you mentioned the social compliance department. A lot of these companies likely don't have a social compliance department. So, how do we look at that as well? So again, just any thoughts on that? And I hear the same question all the time. Well, they're not going to want to give me that information. So what's the best way to address that?
Yeah, years ago, we used to deal with textile quotas, things like that. Back then, the whole issue of where things were produced was a big issue. You can put anything you want in your agreements. I mean, your contractors are going to agree to it in order to sell to you. When push comes to shove, the question is, based upon your relationship and your market power over them, whether or not they're going to comply. So as a small or medium-sized importer, you may not have much leverage to be able to use that, so it becomes a problem. Even if you agree to protect them, when the questionnaire comes out, whether or not they're going to be willing to assist you is always a big question.
Amanda, do you have anything you want to add to that at all?
Yeah, sure. To your point, it's even more difficult for smaller businesses, but I recently had helped, it was a disposable glove company whose tier 1 supplier they had a long-standing business with of buying those disposable gloves, and they would not reveal who the supplier of the rubber latex material was, because at that tier 1 supplier, they're the ones making the glove and manufacturing the finished product, but the secret sauce is really the quality of that material of the rubber latex. And so this was also a smaller importer, but because they're a smaller importer, they've had a long-standing business relationship with one particular factory, and they did have that trust involved. And even though their orders might not have been as big as a larger retailer, they had a tremendous amount of loyalty to them, and I think the supplier knew that. And so the supplier provided to us, through, after putting in place a confidentiality agreement, the name and address of the supplier, and redacted any costs involved and things like that. So just because you're a small importer doesn't mean you still don't have leverage, because you might have that more intimate relationship with your supplier as a result of working, not through just the social compliance department, but having the CEO be in that country, at the factory in order to find the business.
Yeah, and that relationship is key. When we do things like first sale, which is very sensitive information, if you have that good relationship with that first tier supplier, that they are assured that they're not going to get cut out of the loop, that helps. The problem becomes, even they may not know what's going on behind the scenes, because we're taking our jalapeno and olives situation, starts from a farm. That could be a 2-person operation. The documentation's not going to be great. So we talked about this with the cotton. It gets to the next level. It goes to a cooperative of some sort. It now gets intermingled. Does the cooperative even keep records? They probably issue a receipt for 50 bushels of olives, but they're not going to be able to say that these 50 bushels of olives are in your order, unless they're unique in some sort of unique green olive or something like that. So that becomes a problem as well. You now have to get that supplier to get invested in the idea of knowing exactly where their merchandise is coming from.
Yeah, and I would say just one addition to that I've seen actually in the past. It wasn't specifically to the supplier, but CBP did accept that eventually, was related to audits and proofs of audits of in the supply chain that they had requested or required importer. And the challenge that importer had, and I have a feeling that the smaller importers, this might even be more of a situation, was that the social audits included multiple components. They did include a part for forced labor prevention, but they also included a lot of multiple components that were actually protected by confidentiality laws in other countries. So that then you have this conflict of laws. And the reason I've mentioned it to this example is because and in that case, the importer was able to convince CBP to redact, because the audit covered multiple areas, pretty much everything else but the exception that could refer to some of the forced labor questions related to that. And that had to require a lot of, I would say, conversations and collaboration, not only with council, but also with CBP, because in the initial request, CBP would not agree and they just wanted all these audits. So there's also this part about the importance of council, no matter how big is your company or how small, and then how close that communication with that delicate dance can be with CBP or the agency.
There is a question, somebody wanted to know if there's a question, there's any concerns with OFAC?
Well, depending upon the countries we're dealing with, and now with,
Right.
if you're not familiar with the export controls, there are a number of lists that the government has created. Denied entity lists, specially designated nationals lists, narco terrorists. I mean, there's all sorts of these lists that list various individuals and companies. And, you know, as you dig into this, you know, you may run across something like that where it's an individual that you shouldn't be dealing with. Well, you're not dealing with them. That's the good part. Because it's, you know, hopefully not your first tier supplier, because that would really cause a problem. You know, it would be further on down the chain. And yes, I mean, there is a concern that if you run across that, probably not a big, well, as we get into Russian sanctions, who knows, certain materials, you know, it's probably not a huge concern, but it is something that's concerned. But also think about it from all your other government agencies that get involved. Do we have a Lacey Act issues? Is something subject to CITES that, you know, maybe got lost in the chain here? That, you know, what's going into what type of, you know, product is this covered by something like that as well that you didn't deal with? You know, when we're talking here about a food product, you know, do they have the proper safety standards with FDA? Are they properly registered? Or, you know, all that stuff. Your first tier supplier probably is, but, you know, as we get down in here, he might have subcontracted some of this to somebody who wasn't. So yeah, all those concerns do come up. I don't think in the context of a WRO review, Customs is going to raise a lot of those issues unless they are, well, I haven't run into it, but I don't think they would unless it was something so significant that it would affect the ultimate admissibility of the good.
Yeah, so to David's point, you know, what we focus on and what David and I specialize is import law, and the WROs are on the admissibility of imported merchandise, and OFAC concerns deal more with export controls. And so you do need to be prepared about, you know, what materials are sent to your factory, because that could be an export controls concern. But I do 100% agree with David. It shouldn't be that big of a concern, but it's something that you should be screening for. And we have yet to see what the effects are of the UFLPA, but the Uyghur Forced Labor Prevention Act. But once the Secretary of State publishes their lists and the task force publishes their list and President Biden has to publish his report, it's very possible that there are sanctions linked to these Xinjiang entities that come out throughout that process. So the OFAC concern might become an issue for, you know, items sourced from Xinjiang, but we will all be monitoring it. I'm sure you will, and see, you know, what names and entities are on those lists and sanctions that might arise.
Great. So we have another question, which of course is a great question, and it's probably in everybody's mind that's sitting here listening to this right now. Does all the work have to be done in advance, considering the onerous amount of work for hundreds of factories? It's a great question, and it's you know, it's a practical everyday question. Is what does CBP expect an importer to do? So, you know, again, I think you maybe just some thoughts on, you know, how do you manage this? You know, and you get two things, just to reiterate the question, one being if you have a situation when your shipment is detained, but also if you're just trying to do your due diligence, you know, for forced labor. And so I think this question is kind of relevant to, okay, I want to stop my due diligence. So, you know, what do you guys think?
Well, you know, I mentioned that a little bit earlier, you know, paying attention to the trade press. You know, that gives you the risk-based targeting.
Right.
Customs famous phrase. You know, that, you know, where do I look? You know, if they're talking about, you know, jalapenos, you know, all your jalapeno, you know, wherever you've got a jalapeno, because remember, it covers in any part, including one of these materials. So it could be a small component in whatever you're looking at, whatever product you are. So, you know, trying to figure out what those risks are is the, you know, the first level. And then once we've identified the risks, we're going to be, be able to focus in. with the Uyghur, the whole idea is that they're going to be publishing these lists, which will be telling us that these are the places you have to look. So.
And I think in addition to that, because there's been a lot of push to trade from organizations as well as recommendations that have been publicly made from COAC and others to CBP about giving more direction and specifics of what might be their targeting parts. And in fact, that recommendation that I had mentioned yesterday about the importance of interagency collaboration, it was part of that, because one of the things that the trade was asking, similar to this question, is can CBP give general guidance so companies can be better prepared to do their risk mapping or whatever it is? And the response from CBP, at least to my knowledge, and Amanda and David, you might have some others, is, well, look at the entire framework, look at previous WROs, look at the International Labor Organization, which is published, what are the target areas, and their position has been consistently, companies should have enough almost general awareness of what are regions or commodities or certain areas that are risky. And what I think we found across companies, that companies may have that and may start at that level, but they come short because they say something like, oh, jalapeno stuff, olives or whatever. Oh, I don't import that. I only do olive oil. I'll make it up. So they're like, I'm not in risk, but there are also these kind of like parallels that come to it. So I don't know if that helps. And Amanda, do you have some other thoughts?
Yeah, so, the question is, does all the work need to be done in advance? The strongest takeaway from this would be, do not do the work retroactively. Make sure that your factory is not providing you with production records that are supposedly from 2020 and they were generated in 2022. In terms of the, what work should be done in advance, that's why this is an overwhelming change in the landscape of what needs to be done. And I think small steps in terms of enhancing your supply chain controls and, first getting that mapping done is something that can be done in advance. You can then consider revising your purchase order terms and conditions next. And, little by little, prepare for this. It doesn't all have to be done at once, but you want to start preparing for having those supply chain controls in place, because to David and Erika's point, the Department of Labor had published a list of, high priority products, and something like toys was on it. There's no WRO right now against, a toy factory or a plastic injection factory or something like that. But, if you make stuffed animals that are of rayon and, stuffing, in the government's mind, they already gave you notice that this industry is, one that should be aware of all of the forced labor concerns. So it would be impractical and hard to do all the work in advance with hundreds of factories, but you should start putting those systems in place and, maybe start with one of those hundreds of factories that is either in NGO reports or in the news, and start opening those conversations and putting in place those controls little by little.
Great. Yep. Great recommendations. Obviously, one of the things is, working with your suppliers, and I think you guys talked about it, getting things in your agreement, that they're going to cooperate. We talked a little bit about that yesterday too, for whatever their work, the agreements are worth, but, things like if there's a problem, that, they're going to cooperate, they're going to pay for the goods to get, to be exported back to China or wherever they're from too. So let's go back to our jalapenos for a minute, and let's just kind of, maybe we can discuss the types of documents, perhaps, just maybe on a broad range, what types of documents would, somebody be putting together? So I know we talked about yesterday, and Therese talked a little bit about it, but, maybe kind of try to give an example. Okay, you know, I'm buying these jarred stuffed jalapeno stuffed olives from Mexico, but the jalapenos are from Guatemala. What do I need? What types of documents should I be thinking about as far as responding to CBP?
Well, and at least in my mind, the way it works, it's best to start from here and work backwards. Because as Amanda mentioned in her presentation, the idea is connectivity of all those documents. So we have our documents from our exporter, you know, starting with those, you know, what's his first contact with anybody beneath him, and getting those documents and then working your way back. And in the case of an agricultural product, we're talking all the way back to the farm is probably the issue. And, you know, unless the WRO is something in the middle there, whether it's processing of the olives or, you know, but, you know, so by starting with the, you know, the exporter's records, you know, what's the next tier? Okay, get that in order. And but what happens when you do this is you start getting a branching effect, you know, sort of like a family tree. You start with one person. You know, we can all trace ourselves back to Genghis Khan, you know, but there's, you know, all of us people, you know, there's a long list of suppliers that now get involved. You know, we're talking about an agricultural product, you know, where did he buy the olives? He bought it from a cooperative. The cooperative bought it from 30 different, you know, farms. You know, it starts getting, you know, almost unmanageable to a certain extent, you know, depending upon the nature of the product. But the key is get the best you can, document what you can document. You know, the standard is very high for the proof, but, you know, you got to try, you know, your best to sort of clear those out, you know, where we can tie it in.
I'll share my screen with the slide of the traceable records if you want. Can everyone see this?
Yes.
Yes. So, you know, David just nailed all of the bullet points. But to his point, it could be overwhelming. So I would recommend attack each tier with the checklist of those documents that you need. So, you know, to David's point, start with tier 1 and make a checklist of the transactional, transportation, production records, and affidavits that you'll need. And then, you know, you can have at the top of that folder or Excel spreadsheet, however you're collecting the documentation, the name and address of the supplier that is owning those documents and accountable for those records. And just create a checklist for each tier, because if you try and collect them all at once, it certainly becomes overwhelming. But to David's point, just do the best you can. And, you know, if they can provide you with the transactional records, but not the transportation records, well, maybe on the transactional records, there is a, you know, bill of lading number, or it lists the address from which factory or ginner it then was shipped to. And so, you know, trying the best you can, getting as much as you can is really your best approach, in my opinion.
And Amanda, if I can add to that, from the internal part of the supply chain and the practicality of it, very important as the functions are looking to these different elements of the dates, the quality of the records and the realities. And it could be a big company, it could be a smaller company, but the farther you start going to the supply chain, sometimes, especially you get involved in some of the commodities that David mentions, that you go back to where it was grown, and they might be through a cooperative, and then they get commingled, and then they get through some other cooperative that sells them, etc. Sometimes what we've seen when we've done some of those mappings is that the information is, for instance, on production records, but it's really just an Excel file. It doesn't have a date and it doesn't have a signature. And CBP would say, well, who actually, is there a plant manager or is there like a supervisor? Like it has to be somebody knowledgeable, and I don't know what's the legal term of that. If it's a small company, it's not going to be an officer, but somebody that they can actually go and if they need it, we could do even an in-person visit. So proactively, I think as the companies are looking at these very good checklists, is the quality of the batches. And by the way, in my experience, CBP has said, we understand that you might have some receipts or information that are handwritten. That's okay, but they better have a date. You be better able to link, as you have here, some type of bail to some other patterns that you can really trace it. It is overwhelming, but they shouldn't underestimate those elements because they're very important.
Yeah, and again, I mentioned back in the days of quota, with textiles, all ended back in 2006. Probably nobody remembers this, but me. That we had sewing tickets, which were individual workers' piece counts that then got summarized in handwritten books of floor managers, who then those were summarized perhaps on an Excel spreadsheet if the company was sophisticated, but even less so, on tally sheets. And with all of those, and I think Amanda mentioned this in her presentation, with trying to show that the records actually relate to the transaction is always difficult. An affidavit, I am so-and-so, floor manager of X, that I certify that these records are for, X date to X date and truly reflect the operations of the company. If you can get that signed, it doesn't have to be a formal affidavit. It could be just a letter to that effect to support their, records kept in the ordinary course of their business.
We have another question. If the WRO was on the on the olives, well, we were saying it was on the jalapenos, I think, but
Let's do both.
so if the question is, if the WRO was on the olives, do you need to trace back the packaging and other ingredients from the plant, or do you just focus on the olive product itself?
And if you'd
Yeah.
like, yeah, go ahead. See your
Yeah,
button.
sure. Erika had mentioned, really know what that WRO scope is. And so in this case, I would focus on the olive product. It would likely be the tier 1 processor. And then if it's on olives, the, tier 2 olive manufacturer, if that's the way the supply chain works. But yes, there would be no need to focus on the packaging because there would be no concern of forced labor on the packaging. It would be that olive and then any, downstream product from that olive, which would be this finished jar of jalapeno stuffed olives.
And it's interesting looking, parsing apart the statute and the regulations. It says manufactured in part. Okay. So we're talking about the product itself. There's actually a ruling out there on packaging.
Yes.
And forced labor. If it's the olives they're focusing on, the fact that the glass jar that it's in was made with forced labor is, while I would be concerned about it, technically that's not what the WRO covers. So, it would not be subject to it.
Right.
Now, if in the process you come across that there is forced labor used in other products, you've got a different problem.
That's a
More of a
different
social
problem.
compliance issue than a
Right.
A legal
Yeah.
issue. But yeah.
Right, exactly. Okay, so those are great. So do we have any other thoughts on the jalapenos as far as the types of records? I think we're pretty good with the types of records you're looking at, and the idea that you want to be able to trace back, from data, import all the way back. Can I ask a question just to get your thoughts too on worker records? Factory records, are those things that that CBP would want?
You mean like
Okay.
attendance records?
Yeah, just to see, who the workers are. I mean, have they been,
I
getting
would
it
love
back?
Amanda's and David's response because I can say the pushback from trade to CBP on that, what it was. So I'll let Amanda and David go first.
Go ahead.
Yeah, again, get all the records you can, especially right now with the Uyghur Forced Labor Prevention Act governing not just products that are sourced and manufactured from Xinjiang, but if the labor was transported to, Guangzhou, let's say, and that's a Uyghur Muslim working in that factory, then it's, and customs knows that, it's possible that customs is aware of this problematic, let's say, factory that is using Uyghur Muslims in their factory in Guangzhou, and your product might be detained once the Uyghur Forced Labor Act, Prevention Act, goes into effect. So that, I guess that's not really answering your exact question, but the more, knowledge is power. The more you know about the supplier and the manufacturer and those involved in the manufacture, the more you know.
And I think what Erika was alluding to is, from an industry standpoint, if we're talking about the olives, and the harvesting of the olives, let's say that's where the forced labor was used. What do we care about the worker records in the processing plant?
Right.
They're not under forced labor.
Right.
If we can show it was processed at that plant, that's all we really need to show. But you got to remember, the person on the other end in customs is probably working off a checklist and saying, okay, have I gotten these records? Again, harkening back to the days of apparel quotas, I know that's what they did. So if you didn't meet, if something was missing in that chain, they made a big deal. So, do the best you can. If there's a reason that the records are not being supplied, you got to put in a good argument why they're not being supplied.
Yeah, and David, I think that's the key, because I think the push from industry across industries, and I think it was a valid one, was this ask about worker records is very broad, and other parts of the legal teams on that, when this touches countries and factories that are in different locations, the concern was, well, we also have to abate of confidentiality workers' information on those countries. So I can, whatever the country is, I cannot just share all those records for brokers because CBP wants to see them, because then we might have another conflict with some other conflicting laws. So that was part of some of the push, and narrow it as much as possible, because of course, on the other side of the request, to your point, CBP has a checklist, but there has to be some type of back and forth on that.
Just another question here. For those of us working in the real world, how do we really deal with commingling? And any thoughts on that? Ideas, best practices.
Well, in reality, there's no easy answer, but if you can show that it came from 7 different farms, and those 7 different farms are not one of the farms that has been designated, you're going to be okay.
Right.
The problem is, did they ever deal with, let's say, the bad farm? Is there any residual amount left? Yeah, I mean, look, we're trying to prove the negative. Could somebody at customs say, well, you didn't prove that this didn't come from, so, it becomes a very difficult thing.
Yeah.
You do, again, you got to do the best you can.
You can also, consider some suppliers are vertically integrated, and then that is helpful to, get back down through the tiers to know that whatever is in their inventory was, if it was I keep going back to the Xinjiang cotton, but that's because I can't sleep at night because of that issue in particular. But if you have, a vertically integrated factory that makes its own yarn and its own fabric to make the garments, and they have a policy where they do not, ever use, let's say, Chinese cotton. Well, their inventory records and everything will show that they don't use Chinese cotton, and therefore they certainly don't use Xinjiang cotton. And so, to David's point of proving a negative, it would be their entire inventory to show there's no way there's Xinjiang cotton in here because we only use, cotton from India. Also worth considering certified materials. So if you use Supima cotton in your 100%, I'd say 100% Supima cotton in your products, then that's presuming that all of that cotton is from the United States and not Xinjiang. So commingling is that's to me the hardest hurdle. That, hopefully the guidance that comes out of customs and the updated regulations that come this year address that a bit more. But when having to prove the negative, there's some tools that might be costly or, at a premium, but they do exist to minimize that risk.
Yeah, and the other argument, it's an argument rather than actual proof, is the economic viability. You're talking about shipping, raw cotton from the center of China to, one other place that, for use. Is that really something that's possible? I mean, the economic viability would make the value of that cotton so huge. Why would I ever use it? Especially in a cotton producing country. I understand that's come up recently with a US based cotton company that, they were saying, well, how do you know it's not coming from China? We're buying it here in the United States, which is the biggest producer of cotton. Come on. There's only certain much you can show.
No, that's an excellent point. Oh, go on.
No, I was just gonna say, if there is a question that comes on that after, you do bring a good point that I keep hearing about trade, and is the whole concept of transshipment here, but for the sake of forced labor, which might be inadvertently, and goes back to what exactly CBP is gonna be looking at, like that example of the olives. If the WR is from Guatemala, but you are doing some processing in Mexico, then do you have them to provide records for your transshipment in per se? So similar with the cotton, and I think that's some challenges that CBP is having on that as well.
Yeah, and as we're all becoming knowledgeable in this, we're learning about the supply chain that I don't know if customs was an expert on these commodities and these supply chains before these WROs came out, but I had worked with a client who had detentions of tomatoes under the Xinjiang tomato WRO, and we proved, we were able to show where the tomatoes were processed, and we were able to show that it was hundreds of miles from Xinjiang. And to David's point, you're not going to truck a tomato where there's the water weight involved. It would just be cost prohibitive to truck tomatoes from Xinjiang all the way to where the the production was taking place. And so there are, cost prohibitive rational theories as to why there's no way the material came from the region that there's a WRO on.
But to the point, does that necessarily always fly with customs?
No.
These shipments were released. I don't know if that was why or because they had
Just
stellar records.
Throwing that out there.
But you're
Like I
absolutely
said,
right.
The records were outstanding.
It's an argument. It's not proof.
Yeah,
Right,
exactly,
right.
exactly, because it's not always.
It leads, the issue becomes the standard of proof.
Right.
The UGAR, it's going to be clear and convincing. That argument's not going to fly.
Yeah.
But on the probability level, yeah, it probably does.
Yeah. Hey, a good question that came through the chat. How does CBP verify that any of this documentation is real and not doctored, especially when tier 2 or 3 is government backed? And how does a company verify internally? Do you accept the documents on their face? Do you try to just use it as a reasonable care view? Thoughts on that?
Erika, any thoughts?
Well, what I would start with, and I'll pass it to you, is that the burden is always on the importer.
Right.
And I don't know how else to say it. And also, and I don't know, because it goes back to resources and all this stuff, I'm always fascinated to hear from my legal colleagues on CBP that are counting on that. But CBP says it has authority, and I know cases that they will actually physically go and said, okay, you told me you have these tiny farm or production facility somewhere in the middle of the world, and they would go and they would be, and sometimes the importer might not even be aware that they have already made some of the visits in the area, and it's very hard to prove when the burden is completely on the importer. That's how I would leave it and pass it to the legal experts here.
And it's a matter of common sense. You know,
Yeah.
if the documents look like they've been doctored, that's simple to spot.
Right.
The problem is, and we've had this happen, the documents are just too good. You know, it matches down to the individual units. It's going to match, you know, everything just ticks and ties beautifully. You know, you know, that becomes a problem. The other thing, as you said, you know, customs may have already been there. Again, getting back to the NGOs and the other ones, they may have gathered documents and passed them along, and these don't jive with those. You know, that's always a problem. You know, years ago we had, again, going back to the apparel days, you know, customs had been in a factory. They had taken photographs. You know, as part of the production documents, we showed photographs of the production facility. Customs says that doesn't match what we saw. It's like, so, you know, 1 week there was, you know, 3 sewing machines. Next week there were 300. You know, it's like, it's a problem. You do have to rely somewhat on your suppliers, but again, like I said, I think, you know, taking a common sense approach, looking at the document itself to make an assessment of it, and cover yourself. You're not vouching for the supplier and his documents, and you want to make that clear. You're not certifying that these documents are true and correct. This is what I received. Now that may tank your submission, but it may keep you out of jail if they're fake documents.
Okay, so let's just take a little bit of a turn here. So we're done with the jalapenos, but let's just say we've got a, you know, maybe a different type of a product. So we've got we're going to use a baby's rattle made of wood, and it has some little plastic beads inside. But this time we're going to basically say that now the WRO was on the wood. So how about, you know, how do you think this differs? Do you think this is an easier review that it would be in jalapenos? Do you think you need to go, how far back do you need to go on a product like that versus jalapenos? So again, just to kind of show the attendees that, you know, each supply chain can vary as far as how difficult it may be to substantiate something. Anyone's thoughts?
I can just open it by saying that to me, it doesn't change the fundamentals that we have said at the beginning, from the inter teams communication and really effort, because everybody certainly understands how monumental it is. And especially we're talking to medium and smaller companies, there might be not even enough people in the customs function to do this. So anyways, aside from that, I would just say in this example, Paula, it also Depends where are you in that transaction part, right? Are you a retailer? Are you the last part of the, maybe adding the beats or whatever in the production, and what are your terms? But it doesn't change the fundamentals. You need to understand what is the mapping of the supply chain. Is there any risk, at least in general, public information from different agencies related to wood or related to some of the processings that happen with other regions, and take it from there. I'll pass it to my co-panelists here.
Yeah, I mean, Erika said it perfectly, is the same fundamentals apply. Make sure you have systems and documents and controls in place so that you can map correctly and trace correctly.
I mean, you know, if with the, again, with the wood, you're going to run into the commingling issue. You're going to run, you know, there's all sorts of, you know, the cooperative issue. Where is all this, you know, raw wood coming from? You know, so yeah,
Right.
I echo what they have said. Yeah.
And so I do have another question that I want to bring up that I think might be of interest to the audience, and that actually has to do with the language of the WROs themselves, and how they are very difficult sometimes to understand, and also the problems getting CBP to really, you know, quantify any of them. So I think the silica products one is a good example. And I know we talked a little bit about it yesterday, David, when you were covering some of the other WROs, but I know that that's been a little bit concerning because it seemed to be so broad, but we still don't have an idea exactly, you know, what is covered. Although I think I did read they're publishing another FAQ on that very, very soon, right?
Yeah.
That might give a little bit more guidance, but I think that is also, I think, an issue maybe for some companies that, you know, when those are issued, does your product fall under it or does it not? So, you know, just getting back to like the wood rattle. I mean, if it's just, you know, is it going to cover everything downstream made with that wood, or is it just bringing the wood in itself? Because sometimes I think that language is somewhat vague, and I just wanted to see what you guys thought as far as that. Any thoughts, recommendations?
What I'd like to do is share my screen to just show you what you have to look at. I mean, what customs does, and you know, is this showing or no?
Yep,
Yeah.
it is.
It is showing. Okay, I'm just not seeing it.
Yeah, we're
Okay.
seeing-
So this is what customs puts up on a WRO.
Right.
There's not a lot of discussion. There's not, you know, unlike a dumping case, for example, where they can spend pages talking about
Yep.
the scope of the case. Here it is very straight, simple language about what the merchandise is, what the entity is. I suggest you look at the press release as well, because that gives a little bit of flavor to it. And, you know, with the silica products, they're starting to, you know, they issued some frequently asked questions. They're adding some more, from what I understand. Same thing with the JUR WRO, you know, that's really all you can do. Now, looking at these descriptions, it's pretty easy to figure out whether your product is, you know, silica-based products. Does my product have any silica in it? That's my question. And where's that silica coming from? So in most cases, it shouldn't be a problem. As this progresses, who knows?
Right.
Some it's all products.
Mhm.
Makes it easy.
So here's a question about our case study on the wood. Is it the harvesting prompting the WRO, or the processing of the wood? Again, it's a great question. We don't know. So, I mean, and I think that kind of covers the discussion we just had, that you really have to look at the language of, you know, where was the alleged forced labor? Is it when the wood was harvested, or was it when at a, you know, factory where the wood is processed? I mean, those certainly could be at issue, I suppose.
Yeah, And what I would add to that is that if there's that example, and then you certainly have make the stair rails or whatever, and you see that there is a WRO in wood, like the first thing I will start looking at is more or less how does our supply chain get back on it, because I know at least that there's a component in something that I sell or I import that is part of that WRO. So aside of then getting the specifics and mapping, at a minimum, I would have a general look at that, which I think is honestly something similar that all companies are starting doing with the cotton part. Before we got into some more of the details ones, where there was retailers of others. What the retailers did before trying to find out all that, they started contacting all of the suppliers and saying, I buy t-shirts from you, you tell me how far it goes. So again, if there's a WRO in a component or an item or a material that you sell something processed with at least the same type of it, I would at least start looking at a bit into that mapping.
And, looking at the map, the correlating entities that they've met, so it will tell you at what level, going back to palm oil, they mentioned this two multi-level integrated producers that basically covered the farm to the finished product. So, that made it a little bit easier to understand what they were talking about. So, because they touched it, but the ones on hair products, I believe it was the hair that was harvested from prisoners was the ultimate issue, but it's the factories that process that hair that was the issue. So.
And does anybody want to comment? I know that this has been an issue with the silica on the de minimis. And I don't know if Erika, maybe this is something that the trade may have discussed, but I know you probably can't discuss it.
I'm not gonna attempt to, I have my own thoughts, but we have great two lawyers here, so I'll defer to them.
Well, if I read it correctly, didn't Customs pull back the de minimis question?
Right.
Yes.
They did.
And
Yes.
Go ahead.
Oh, I was just going to point out what David had pulled up before, where next to each WRO, it includes the press release for easy access, and then there's an FAQ for the Xinjiang cotton and the Hoshine. That FAQ, to David's point, changed in terms of the de minimis a few weeks after it was published.
Yep. And I guess my point was, does anyone think that at some point CBP may decide to include a de minimis, or no? Do we think that may not happen for any cases future, going down, just that, if it's this percentage or this value, we're not going to include it? Or do we think that the general consensus is that doesn't matter if it's, 0.5% of the product, if it's got that cotton in it, it falls under? Does that seem to be the mindset with CBP, do we think?
Well, and this goes back to the statute, unfortunately, because it says in part, in any part, I think is the actual language. So, can they do a de minimis is the issue.
Right.
Now, but in the reality factor, who are they going to target? If they think there's a small percentage on certain products, that's one thing. They may not target that section of the industry. If there's a higher percentage on other products, they'll probably target those rather than, because it's a matter of cost and benefit, and what is the best, what's best will get bang for our buck here. Is it going after the big guys or the little guys, and that are using just a minor amount? But in our submissions on these, Customs has said prove that there's no cotton from the region, and that's always a problem.
Yeah. So, to David's point, there's no de minimis provision in the forced labor laws, and as Erika was shaking her head before, there's policy reasons, of course, why there wouldn't be a de minimis provision. But what is interesting is there is case law to support the fact that, a century ago, there was a judge who it was dealing with opera glasses and the metal in it, and there was case law to interpret whether there should be a de minimis provision in the forced labor laws. And unless this goes to the Supreme Court in the next few years, I doubt that case law will really apply to how customs interprets the law now, but there's a glimmer of probability that, if this was to go to court, there could be an interpretation by the court that there is a de minimis part to this.
But at this point, I don't think the administrative agency is
No.
entertaining,
Agree.
other than that bizarre thing that was in those FAQs, which I don't know how that got through. But,
Someone didn't do a good job proofreading, obviously. Because I think everybody jumped all over it and said, well, wait a minute, what about all these other WROs? They must have de minimis too. Hey, just throw something out here too, getting back to, depending on the wording of de minimis, the wording of the WROs. I know that CBP has stated that you can submit ruling requests related to forced labor. I know some of them, it's been just, documents that they may accept, things like that. But any thoughts of, submitting a ruling request saying, does my product fall under a WRO? Is it, I just kind of thoughts, has anyone thought about that at all? Or is it, just because it's a tomato product or a computer part or has some silica in it? I don't know. I'm just kind of throwing out whether or not that, there's any, have you ever seen any situation where you might say, I'm not sure whether this product actually falls under this WRO, should I get guidance from somewhere?
I have not contemplated it, because
Yeah.
the idea would be, in order to prove that, one, you'd have to admit that there's a possibility that something in there is subject to an WRO, and then you're in the mode of having to prove that there isn't. So
Right.
it's either an all or nothing sort of situation.
Yep.
Yeah.
Good point.
So I've thought about this, and to David's point, then you are going to have a public ruling where your name is linked to
Mhm.
forced labor. And it
Good
could
point.
mean that you
Awesome.
are proactive, you are making sure you are as transparent as possible,
Right.
but that is a business
Right.
consideration that, it can't be pulled back. Even if that ruling was revoked, it was still made public. But customs is encouraging more, forced labor ruling requests to be submitted. What I am still trying to figure out is, okay, so you have this ruling, this binding ruling that says this supply chain is clean, these records are great, but that is, the regulations for ruling say that that ruling pertains to that particular transaction, right? And so, if you have an import of, let's say, the wooden rattle with the plastic parts, who's to say that the plastic comes from the same supplier, or I guess the wood, if the WRO is on the wood, who's to say that that factory that you got the ruling on is going to be using the same wood supplier for the next transaction? And so it's also like, what is the effect of that on your supply chain as it evolves and the sourcing changes a little bit? Oh, go on. Yeah.
No, please finish, madam.
Oh, no, and just, when you get a classification ruling, let's say, I always encourage people to include it on the entry summary so that they don't get a CF-28, for instance. But is that uniformed officer who's detaining your goods going to say, oh, there's a ruling issued to them, let me just let it go. I don't know about that. And then once that detention notice is issued, you have to provide the documents for that entry, for that shipment, for that detained merchandise. So I understand the customs is encouraging these, and we'll see as they are issued how in practice it could be effective and helpful for importers. But at this time, I just have questions on that.
Yep.
Yeah, and
Oh, go ahead, Erika, I'm sorry.
No, I was just going to say that I know the industry feels very iffy about this, and by industry I mean trade, because it's almost for all the reasons that Amanda and David already shared, but also it falls under the same encouraging that CBP is doing to do voluntary disclosures in forced labor and come forward and then with remediation and mitigation. But CBP has still not been able to acknowledge that the mitigating factors that do fall under other voluntary disclosures apply for forced labor. And in fact, that's another of the very specific long and open recommendations that COACT did, which was related to that even in the case of companies that were trusted traders or ISA, there was really not guaranteed that there would be a different treatment of coming forward if there was some presumption or at least some knowledge that there may be forced labor and coming forward with CBP. So why would they do it? So I just kind of feel the same way about rulings right now, and I think the trade in general is very sensitive to that.
Yeah, and there was a question here about how long a ruling request to headquarters would take for them to issue. And by the time you get the answer, they it could
You're
be
retired.
It could be that the WRO has been lifted by. But and it's a great question because it's a practical question. You know, CBP encourages the rulings, but again, if you make it so long to get what's the point of it? And you know, I mean, I think something like this is different than a classification ruling. And, you know, again, you don't know, they send it to headquarters and it could take a couple of years before you get a decision back. So,
yeah, and it's a great question because, you know, to Paula's point, classification rulings, typically they are sent through e-rulings or the portal to the National Commodity Specialist Division, and they're handled you know, at that level where they have the N next to it. And those by regulation should be issued within 30 days of submission, or you'd receive a letter asking for additional information. But if it's a forced labor ruling request, it goes to the Office of Regulation and Rulings, which to that attendee's point is, you know, the equivalent of headquarters. And then you're considering it to take a much longer time period. It's not going to be that 30-day expectation.
right.
I can assure you it will not be the 30-day expectation necessarily.
And the other things, it's sort of like what they did with certain first sale rulings is they give you this great, your documentation looks great, but at the time of entry, we're going to stop, and you know, it's up to the import specialist to determine whether or not it needs, you know. So, you know, the effectiveness of a ruling too is questionable. What does it get you?
Right. Yep. Good point. So just again, kind of following up on the best practices. So, you know, I know we've talked a lot about you know, dealing with your tier 1, tier 2 suppliers, maybe some thoughts on, you know, best practices you guys have seen, you know, with clients, you know, maybe clients who are proactively trying to address this versus, you know, the clients that have had a detention, you know, recommendations as to, and I think we've talked a little bit about this already, but I thought maybe just to kind of get into, you know, I know Erika started out great, you know, basically saying this has got to be a company-wide project. It can't just be the customs person who likely doesn't, you know, customs compliance may not have visibility, but, you know, just maybe some thoughts, you know, each one of you guys on what you think of as far as some best practices. Whoever would like to start.
Well, you know, start each, just like with anything we're dealing with the import, the idea is exercising reasonable care. We have to be reasonable. We don't have to be perfect. So in crafting whatever you're going to do, again, there's a cost benefit analysis in all of this. Do what is reasonable and what is being done in the industry. Being the best at it is great. It may be for other reasons that you're doing that, but overextending yourself to try to avoid this issue is not something I would recommend. Anybody else okay?
Yeah, mapping, tracing, and get your purchase order terms and conditions in order. Those I think are the immediate importer to act on. And then from there, you can pressure test your system, put it, Ms. Randazzo gave great information yesterday as to the process. And I believe Susan's going to be supplying you with the slides afterwards where, it walks through the traceable records they're looking for, and put your supply chain through a pressure test. Choose a random shipment that you want to reach out to your supplier to and ask them for the documentation and see what you could get.
Yeah, I would just add to that. Amanda said that to me, this part of the pressure test is a really good exercise because it helps you stress what might be some of those weakest links that you have in your supply chain. Hopefully and ideally before you get either a request for information or some product or material involved in that. And it could be as general as literally, as we had said earlier, look at what are some of the commodities, what are some of the regions, what are some of the industries that have been publicly either through previous WROs or the International Labor Organization or things like that, and do that exercise because it would help you not only understand that mapping, but see how strong are those relationships with the suppliers, understand internally what is your social responsibility program, who actually has access to some of that information, understand if your company is doing third-party audits. Sometimes the bigger companies are, and Therese said it yesterday, some companies got a bit surprised because if they got a request for information on forced labor from customs, they said, oh, this is very easy. I have my third-party auditors and they doing all that. And CBP in some cases came back and said, well, those third-party auditors are not specialized in forced labor, so we will not accept it. You should be doing those. So I think it sounds fairly like simple, but this test would be great. And then the last thing that I would ask for a best practice, and I cannot emphasize enough like any other areas in trade compliance, is make sure that your company understands at the top that just because they might not have awareness of being either involved or on the spot of potential WROs or detentions that we've talked before, that you don't need a WRO, but if there's some investigation, you might get those, and that there is support from the top with resources. So the time that you have to respond, you're not scrambling to figure out who's going to pull that, who's going to be the project manager, because you really have to manage this as a project when it comes to respond to customs.
But backing up a bit, we've been talking about the nuts and bolts of trying to comply. From the business perspective, managing your risk, if it doesn't make sense from a business standpoint to do business in a certain country, get out. I mean, that may be the best way to manage it. If there is a risk of detention, you're worried about the costs. Is there some way to delay your terms of payment such that the goods don't get paid for until they're cleared? If there's a question that it could possibly be that, customs hates it, but for a small importer, sometimes that means I can't buy this on an FOB basis. I have to buy this once it's cleared customs. Managing that risk up front, avoid the cost. It doesn't avoid all your responsibilities, but the idea is if goods, if you get caught off guard and if goods get detained, you're not also worried about, the demurrage charges, but the fact that you've paid for 3 months worth of goods, 2 months of which are still on the water, and this month they're sitting in the port, you may never get them released.
Right.
Yeah.
Now, again, that's an issue of market power.
No, but this is I think it's an excellent issue because a part of Incoterms on that part, I think becomes even part of that strategy, especially if the industry moves in some of these waters that have some of the potential products that might be at least in the radar, not that there's necessarily forced labor, because to your point, it might not, you might not be able to give away to that supplier all the responsibility if it's an FOB, because I know cases where CBP has said, I don't care the Incoterm, who's the ultimate principal party of interest in the US, but that internal conversation about who's going to pay for the storage, who's going to pay for the lost goods, et cetera, becomes very critical because it's very expensive.
It just made me think when we talked about the Incoterms about the potential of buying products on a DDP basis and having a situation where goods are detained. I mean, I think some people think, oh, it's all well and good, I bought a DDP, but I think people need to understand that you're not going to get your goods.
Right.
And, I don't know if you guys want to comment on that at all. And I don't know if anyone's seen a situation yet where you've had a non-resident importer of record who has had to respond to a detention notice, and whether or not that's how CBP handles it. Do they send, I mean, I would think presumably it goes to the importer of record, or has anyone seen that? I don't know if anyone, Amanda or David, have you guys seen that situation at all?
I haven't seen them reach beyond the importer because, well, a lot of the goods get stopped at the detention stage. I have had a number of situations with palm oil and some of the other things where they've issued redelivery, but they haven't reached out to where the goods ultimately went to, claw them back. If you can't redeliver, you're the wholesaler, you've imported it, you've sold it on, you get a notice for redelivery, you can't redeliver, you're going to get your bond hit for liquidated damages.
Right.
But I haven't seen customs go the next step and try to, because they don't have authority to seize it yet with the WRO. They have authority to detain it and not release it. They released it. And this happened with timing on some of these. Goods get released and the WRO is published that afternoon. Customs will ask for redelivery on them, but I haven't seen them go down the road and do anything to anybody beyond the liquidated damage claim for failure to redeliver.
So Amanda, have you seen a situation where the importer is outside of the US and does CBP notify that company outside of the US that the goods are being detained? Because
I haven't.
Okay.
But
I'm just curious.
that just
I've
would be
not seen
my
it either, and I'm
experience,
just wondering how that plays, and do they, send something to some company in China saying, hey, you're the importer of record, these goods are being detained because we think they were made with forced labor. And how much cooperation do you think you're going to get from that seller in China?
In other contexts, I've seen it. And depending upon the nature of what's going on here,
Yeah.
sometimes that detention notice gets there 2 months after the fact.
Right.
It's now been excluded, and there's,
And you're the consignee, and they may not give you any of the information. So,
I haven't seen it either, but I might have seen something related that in the current 21st customs framework, whatever is not framework, customs, what was it called, the CC thing?
Yeah.
There was something that I remember reading about that they want to make some changes related to non-resident importers, and I don't know if they could take this into it. But what I have seen is a case where a US importer was very confident because they received product that was DDP and it got detained, and yes, customs went to the importer of record, which was not, it was not the owner of the goods. So the owner of the goods was very comfortable, and the importer of record told customs, well, I just imported it because that's part of my agreement, but actually I literally deliver it and then they reimburse me for everything, and then customs went to the actual owner of the goods, which was not even the importer. I don't know how it was challenged, and there might be things there, but my point to being, I think, Paula, you mentioned it, just because you get items that are delivered DDP, I don't think it's completely like out of the water
Oh, no, I wouldn't think so. And that's why I think just, some companies, it's the same thing, that you listen to somebody in China saying, don't worry about it. I'll be the importer of record, and you'll get your goods without any trouble. And, I think I mentioned earlier, the companies in China that are saying, oh, just send the stuff by DHL and we'll put $700 on the package. So they won't be detected by customs. I mean, those are the things that obviously companies have to watch out for. I know someone commented here that take a look at the, I never say it right, Xinjiang advisory that has the products in the list and things like that. So that will help too. And obviously, the closer we get to the final 180 days, I guess, when we all hope that we're going to get a lot of great information from CBP, hopefully we will get some beneficial guidance. And I don't know if anybody knows, David, I don't know if maybe, is there any provision in the UFLPA that would allow CBP to extend that time period? The 180 days that, where that's when everything is supposed to be. Isn't there a time period when they have to?
Yeah.
Oh, no, I don't believe there is
No, there isn't.
It's statutorily mandated. They've got to get their plan out.
Good. Okay. And do we have any other questions from the audience at all? I'm trying to think if there's anything that we may not have covered. I did want to bring something up just briefly, if we don't have a question, about, has anyone heard anything as far as, I know there's been discussion about penalties down the road for potential violations. We haven't seen that yet, knock on wood, but does anyone know what the latest and greatest might be on that?
Well, there was one penalty. A company called Pure Circle imported goods under, this was the stevia case.
Oh, that's right. Yep.
They had, I guess, gotten out of the WRO, but it turned out the information wasn't correct. And they ended up, I believe, settling the issue with customs about whether they got improper release under the customs laws, and ultimately got a penalty. Whether they did that under the traditional customs penalty statute, 19 U.S.C. 1592.
Yeah.
There is a statute that provides importation contrary to law can be subject to a penalty. And technically, even without a WRO, importation of goods made by forced labor, are, prohibited.
Right.
If you knew and imported it, yeah, I could see liability under that.
Right.
But if we're talking about a knowing importation, there was also a Homeland Security circular that went around with possible criminal sanctions. But I doubt anybody in this audience is contemplating knowingly importing goods that are made with forced labor. None of my clients would do that.
Anybody else have any thoughts on that? And has there been any discussion that just getting to even to like a 1592 penalty, basically saying that, hey, you were negligent or grossly negligent by bringing those goods in. You didn't do enough due diligence. Therefore we're not, we're going to assess a penalty. Again, I'm just wondering if you guys have heard any discussion of CBP maybe going down that route, or whether that's still just kind of floating around.
I haven't heard of any penalties, but
Yeah.
the standard that I think they're circulating that, attendees might want to be aware of is reckless disregard. If you know your supplier is involved in something that's not right abroad and you still are sourcing from them, and that's a risk that you're taking on. So as Erika had said, just because you import DDP doesn't absolve you of any liability, and you do need to exercise reasonable care and know your suppliers, know your supply chain to stay out of trouble.
Yeah. Other than that pure circle situation, crafting a civil penalty here, again, it'd have to raise to the level of a reckless disregard, because, and also, what's the penalty? The goods never were released. It's a non-revenue loss situation where the numbers can be higher as a percentage of value, but there is, a problem there. I don't think there is any sort of easy way to get a civil penalty. The 1307, the basic statute on this, doesn't have any penalties attached to it. There is, what is it, the Trafficking and Victims TVPA does provide for criminal liability, but again, that's going to require a higher level of knowing or a conscious disregard. And it's going to be a very difficult situation for them to do it. Most of the cases prosecuted under that are basically somebody has kept somebody captive as their home aide, and they're the ambassador of Guatemala and things like that. So, yeah.
And my other thought that I wanted to bring up was, now I just lost my chain of thought. I know, Erika, I know you talked, a couple of things. So do we think that we're going to see a continuation of, again, not just detentions, but also CF-28 request for information, and any type of, the audits, the quick response audits or whatever they're called these days. Do we still think that that's going to continue? Will they, versus just detentions? I know we've spent a lot of time on detentions, but I think just again, maybe a heads up that there are other ways too.
I have a feeling that there's no reason why they will not continue. I don't know if I can say they increase or not. And I would say that from benchmarking and across trade, sometimes those requests for information are actually more disruptive with the actual detention, because at least the detention, of course, the value of the goods and all that, but there is a prescribed path for it. The request for information, and certainly Amanda and David can talk about it, but from benchmarking, I've known that they've been through CF-28, which was strange because not related to one transaction, but like a period of time for a CF-28, through these FAFSA, whatever the fast audits responses, through a general questionnaire that CBP didn't say, well, it's not really like an audit, but please answer these 10 pages questionnaire, to meetings where CBP wanted the forced labor division with certain parties. So I think it will increase or continue at a minimum. I don't know, Amanda, the others, how they feel about it.
I'm going to say goodbye, everybody.
David,
Sorry,
thanks so much for
Bye,
everything.
David.
Okay.
Good job. It was, I appreciate your time on this.
Okay, thank you.
Take
Bye.
care.
Bye-bye.
Bye-bye.
Thank you.
Yeah, man, I don't know what your thoughts are. That's
Bye.
like my trade perspective on that.
Yes, this is the era of forced labor enforcement. Buckle up. But in seriousness, Erika said it all correct, that you definitely should expect enforcement using all tools to heighten, and in many cases the CF-28 is more disruptive. For any of you who have unfortunately gone through an audit, that is a costly process that uses a ton of resources. And I think of a CF-28 on forced labor to be a mini audit, because
Yep.
they do have focused assessment audits on forced labor, which is then, you know, another condensed or focused type audit. But, you know, in order to respond thoroughly to some of these CF28s, it is taking a tremendous amount of time and resources. So
Yeah. Yeah, it's very business disruptive. And the one other thing, and I don't know if you want to comment on that, but CBP keeps mentioning it, and Therese mentioned it yesterday as well. CBP, as part of the enforcement, they're also continue to encourage any type of links or allegations that will be brought to them, and they're really fond of advertising the e-allegations portal, which is not the most user-friendly, of course, and it covers multiple topics, but specifically of forced labor. Trade certainly has had concerns about that, because I'm sure nobody really wants to have a willingly forced labor in their supply chain, but then also becomes an element for even disgruntled employees, just like it has for some other types. And while CBP has said, well, we will take allegations seriously, we'll investigate, the reality is that anybody with a phone, with a cell phone, actually wanted to make it an app and provided examples to trade, etc., can put a forced labor allegation, and then the burden is in whomever receives the allegation. So that part with enforcement, and
And the other one you see is to the competitors.
mm-hmm.
The competitors will go to CBP, you know, and you know, allege that they're you know, that the products are being made with forced labor. I know we did have a comment that about it, you know, like should there be a certificate ruling process as a benefit for trade compliance members with CTPAT. And I guess, you know, just some thoughts on that. And basically just overall, how do you evaluate an importer's risk? And, you know, I think for some companies who have taken the step and worked hard to get into the ISA, CTPAT, trade compliance, trusted trade, or whatever it's called today, you know, is there should there be some benefits here with, you know, on this issue? But I don't know if you guys have thoughts for that at all.
Yeah, no, that's an excellent point. You know, you could get a detention notice if you are a CTPAT member or not. And it doesn't, you know, it doesn't profile based on if you've gone through that rigorous process of becoming a trusted trader. But what I have seen is that through your national account manager, your NAM, if you are a CTPAT member, you can have a much more meaningful dialogue with customs on your WRO response, on your submission, on follow-up calls. And so to that attendee's point, I do think that there should be some type of, you know, I haven't flown in 2 years, so I forget what that's called, but when you have like a global entry, I'm sorry, there should be some type of benefit probably for CTPAT to make it a more seamless process through detentions. Unfortunately, there's not. Who's to say that when, you know, the task force is reading through the public comments that they don't consider that. But what I will say is I encourage all importers, if it's possible, to become a CTPAT member, because you really do get a better connection to customs and those who are at the sea reviewing your submission if you do have a detention.
Yeah, no, I will just complement that. I do think that other than providing trusted trader benefits on forced labor, which has been a very touchy topic, the fact that if you are a CTPAT member, as you mentioned, Amanda, gives you at least a seat on the table directly with your account manager is worth it for those tough conversations, and to really educate them in your supply chain, because at least hopefully that would have an impact. And then the second part you mentioned, which I will encourage everybody that is in the call today, is this advocacy. Like, I wouldn't underestimate that. There is on the Uyghur Forced Labor Protection Act, there is a public comments open right now, and things like, would it be a good idea to have a certificate of compliance or something like that? Those are other ideas yes, if I heard from trade, submit them in the public comments, go to your trade associations. If you don't want to do them on like specifically the name of your company or your industry, go to the industry associations. Reach out to the members of COAC and the committees and the working groups, the forced labor group included, because there are other mechanisms to let your voices heard, and I think it's important.
And I think, am I wrong, but I thought that there was a process that you could submit comments, but not your name when you're submitting them.
I don't know. I haven't seen what is it public?
I thought there was. I thought you could still submit and not have to have your name. I could be wrong, but I thought there was a process
Okay, well, that's
just
good.
because of that reason, because I think a lot of companies were concerned about having their name out there. You know,
Not all visibility is good. Like
not all visibility is good. Like, why is that company submitting comments? I know Ursula asked a question about the EU. I don't know, Erika, maybe you know a little bit, because of Biogen. Are there similar directives? I mean, we know that the forced labor is an issue in the EU has issued directives. I'm not familiar with how far they go and how they handled and if they're detaining shipments.
I don't have that level of detail, but I would say, and maybe I'm gonna have some other perspective on these, that just like the US has been sometimes example for trigger and some other regulations around the world, and there is collaboration agreements. Certainly for forced labor is a case with other countries, and to me the closest example would be the specific changes that were enhanced to the USMCA that actually included forced labor audits as part of not only the legibility process if required, but joint audits between Mexican authorities or Canadian authorities or US authorities. So I do think that there are other countries doing that. I don't know how sophisticated are in terms of that. Amanda, I don't know if you have any other visibility of that.
Yeah, so late February, the European Commission had put out a directive on corporate sustainability due diligence, which usually, touches this topic. And it was mentioned that that proposal does not include a ban on imports of products using forced labor, because the Commission intends to table a separate proposal that would specifically address that. So the US has been, ahead of other countries in terms of forced labor, but they're all slowly following suit.
Great. Do we have any other questions from our audience at all? Okay. Amanda, Erika, any last comments you want to make before we wrap up? Any best wishes?
I'll say it's never too early to start pressure testing your supply chain. Don't start pressure testing when you get a CF28
Right.
in any topic. This goes beyond forced labor, right? But definitely is a topic of the year, I guess. I don't know, Amanda, you can close.
Yeah. No, just the fact that you're attending this presentation is already a step in the right direction. You're gaining knowledge on a situation that customs, import council, companies are all learning at the same time right now. So in my opinion, you're already ahead of the curve by doing that. And if you have any questions whatsoever, you can always reach out to me. My email address and direct dial are on my slides, which will be circulated. I'm sure David would say the same. And Paula as well, obviously. So, if you have any questions, just feel free to reach out.
Great. I want to thank Amanda, Erika, David,
My
for your
pleasure.
time. There's a lot of time involved in putting together a 2-day presentation. So I appreciate the time, the time that you put in, and I hope that this was a valuable experience for everybody. And it's a complicated area for sure. There's still a lot of uncertainty, but I agree with everything Amanda and Erika said at the end. It's never too early to start, at least start the process, start discussing it within your company. Don't wait for that CF-28 or that audit or that detention, because it's going to make it that much more difficult. So again, thanks so much to everybody. I mentioned yesterday the CCS points, they will be forthcoming. So I don't know if Susan will reach out to everybody who have requested them, but you can certainly reach out to her if you're looking for them. And I also just want to say, you know, we're still putting together our CONECT programs for the next few months, but certainly keep up. I know for sure that our great port tours will be starting up again in June. So, and I did just see that there's going to be a Zim container ship now coming into Boston again, which is really exciting. So if you've not done the port tour, absolutely take it. It's a great day for everybody who attends. And we hope to have maybe a one-day conference coming up in the next few months. I think Ursula sent out a survey to members to see if they're interested. So please reply. So again, on behalf of CONECT, I want to thank everybody for participating today, and hope to see everybody soon.
Thank you. And thank you
Thanks
to
again.
Diane for CONECT as
Yeah.
well.
And Erika, welcome to Boston this summer. We hope to see you in
I
person.
look forward to
CONECT
be
events.
closely engaged with CONECT and meeting everybody. Thank you.
All
Thank
right.
you,
you.
Amanda, for
Appreciate it.
panelists.
Take care.
Take-
Bye. Take care.
Bye.
Bye-bye.